All right, both sides ready?
Yes, Your Honor.
All right, you may begin.
May it please the court, I'm Courtney Keller, and I represent the appellant, Zenith Insurance Company. I'd like to reserve 5 minutes for rebuttal, please.
All right, you got it.
This case concerns the proper interpretation of Section 440.39 Florida statutes and Zenith's ability to bring a second-year lawsuit pursuant to subsection 4 of that statute. Zenith is a workers' compensation carrier who provided about $2.5 million worth of benefits to Danielle Brennan, an employee who was injured on the job while riding a motorcycle. The appellee, Mr. Ryan Pierce, is the individual who struck Miss Brennan on her motorcycle, and the vehicle he was driving was owned by appellee Larissa Mueller. Miss Brennan is not a party to this lawsuit. So we're here, Your Honors, on a de novo review of the trial court's grant of summary judgment in favor of the appellees. The trial court granted summary judgment primarily on the grounds that Miss Brennan, the employee's settlement with the tortfeasors here, Mr. Pierce and Miss Mueller, that her settlement with them barred Zenith from bringing its second-year lawsuit under Section 440.39(4).
Would you agree with me that if we allow your suit to go forward and we reverse this, that your insured will be subject to a claim for indemnification by the third-party tortfeasors, a carrier?
That Miss Brennan would?
Yes, you're insured.
I think that is an issue that is possible. I think that
Is that what this statute was designed to allow?
Well, the statute, Your Honor, was designed to protect the employee and the employer. It was not designed to protect the tortfeasors. And let me back up. I don't know that
your lawsuit does not protect your insured at all, because she settled her case for a full amount and released the tortfeasor carrier and the tortfeasors and agreed to indemnify them and satisfy your client's lien.
So if we look at the release, first of all, she doesn't necessarily agree to indemnify them. And that's, I may have misspoke earlier. She agreed that she would take care of the liens of the insured, but she did, those words indemnify are not included in that release, first of all.
What else does that mean?
I think it's her agreement that she would take care of, any other insurance carriers that may have provided benefits. But
does it expressly exclude your lien?
No, it does not.
Okay.
I think and this kind of gets us to the ordinary subrogation principles of general insurance law. Under those principles, if the tortfeasors are aware of the claim by the carrier, the workers' comp carrier here, if they're aware that the carrier has provided benefits to an injured employee, and which they were here because Zenith provided both of these tortfeasors with notice that Zenith had was seeking reimbursement for its subrogation rights. So under the normal subrogation laws, with the tortfeasors having knowledge of that, the release from the employee to the tortfeasors is invalid, and it can't release the claims of the
Cite me a
carrier.
case, please. Please cite me a case for that proposition.
We cited the case of Twin City versus, I'm getting to it here.
Because doesn't 440.39 clearly in all subsections 1, 2, and 3 allow the employee to settle their case within that year?
Yes, subsection 3 definitely allows the employee to settle.
And that's what Miss Brennan did, correct?
Correct, but she did not file a lawsuit.
Wait a second, let me finish. And if she doesn't satisfy your lien, you have the right to intervene in court to get your proportion, correct?
I don't think that's how the procedure goes under the statute.
That's what the statute says. If you disagree on the amount to satisfy the lien, you can seek court intervention.
The subsection 3B states that if the parties are unable to agree then the circuit court of the county where the action accrued shall determine the amounts to be paid to each. It doesn't require Zenith or the carrier to intervene in the lawsuit. It's really, I think, the responsibility of the injured employee or the tortfeasor within that first year, because Zenith had no idea that a settlement had even occurred.
Well, I get that. I think Morgan & Morgan dropped the ball in this particular case, and I think they're trying to clean it up. But let's just exclude that for a second, because here it appears to me, until you get to subsection 4 after the first year, the employee is in control of their claim. They can file suit or they can settle. Your argument is simply saying the fact that she did not file a lawsuit in the first year entitles you to file a lawsuit against the same tortfeasors that she's already filed a claim with and has fully resolved and fully released. So you're saying that she has to file a lawsuit and settle or get a judgment to bar your lawsuit. So the fact that she settled makes a difference, and you can still move forward on your lawsuit to sue a tortfeasor who's already paid their limits. Is that your argument?
Your
Is
Honor,
that
yes.
what the legislature intended? Double recoveries.
No, I think that this is preventing, first of all, it would prevent a double recovery, requiring the employee to file a lawsuit after she's settled to distribute the proceeds within 1 year. Here, the employee slept on the settlement for over a year, and it wasn't until after Zenith filed this lawsuit that the employee actually then filed her Manfredo distribution proceeding to distribute the settlement that she received over a year prior. So if the statute is read the way Zenith submits that it should be read, Ms. Brennan would have had to have filed suit within a year to distribute those proceeds, and then there wouldn't be any double recovery. But here, it sort of begs the question, what would have happened if Zenith wouldn't have filed this proceeding? Would Ms. Brennan still be sitting on, her $300,000 settlement?
Yeah, but Zenith simply filed the lawsuit because you found out about the settlement.
No, Your Honor, that's not
true. You
true.
didn't intervene in.
No, we didn't know
None
about
of
the
this
settlement.
is in the record. None of what you're telling me is in the record. This all happened subsequent.
No, it's in the record. It's in the record, Your Honor. Zenith sent Ms. Brennan. So the facts here are very critical, and I would like to address those a little bit, and I think it will answer your question.
Didn't she settle this case within that first year?
Ms. Brennan settled very quickly 2 months after the accident occurred.
Okay, so she wait a minute, she settled and executed the release within a year, correct?
Yes.
Okay.
Yes.
So the claim is resolved within the first year.
No, because she needed to then bring suit against Zenith to distribute those proceeds, the Manfredo distribution suit, which she did not do until after a year and after Zenith filed its own lawsuit for the second year lawsuit. Zenith did not know that Ms. Brennan had settled at the time it filed its second year lawsuit, and that is in the record.
Zenith using the tortfeasors as the stick to be Brennan, basically. The tortfeasors settled their whole claim. You're using them as the stick to get Ms. Brennan to do what she should have done.
Well, basically. I think we're trying to get the tortfeasors are the ones with the liability here, and I think as to Zenith, because that settlement was ineffective as to Zenith's right of reimbursement, because they knew about Zenith's right to reimbursement and they settled anyways. That's why we are entitled to still go after the tortfeasors in the second year. And Your Honor, that's in that case, Twin City Fire Insurance Company versus Jones, which I was trying to mention to you earlier. This is a 50 CA case out of from 2006, and there are similar cases throughout the state of Florida that say that although the general rule is that a insured can release a claim against the of subrogation on behalf of the carrier, there's an exception to that rule. And when the tortfeasor knows about the carrier's right to reimbursement, then the insured cannot release the tortfeasor's, or cannot release the carrier's claim for reimbursement. And that's in the Twin City case. It's also in various other cases that we cited to the court, including a second district case. The court mentions it in passing.
But she did not release Zenith's claim. She agreed to personally satisfy it. She didn't release it. She agreed to personally satisfy it. What you're getting into, because you need to read the record below, because your co-counsel below told the court, we intend to file a tort action against the third-party tortfeasors. Ms. Brennan has already resolved her tort action. You do not have a tort action without your employee. Any action that you have derives from the employee. The employee has already extinguished her right to resolve her claim. You cannot seek any more tort benefits. This is a double recovery you're seeking.
We're seeking, Zenith is seeking its own reimbursement for the amounts that it paid out, which were not.
Because you're upset with how much she settled for. And you have a right. The statute gives you a right before you get to subsection 4. The statute gives you a right to go in front of the trial court and argue that they did not settle for the full amount of this case, the full value. It also gives the employee the right to do that too. And the burden is on the employee. The fact that you are given a lien in subsections 1 through 3 gives you that legal right to intervene. If the employee does nothing at all for a year, then you have the right to an action, ma'am.
There's two issues with that, Your Honor. First of all, Zenith was unaware that there was any settlement within that first year, so it could not have intervened in anything during the first year. Zenith became aware of the settlement when Ms. Brennan filed her Manfredo distribution proceeding a month after Zenith filed this lawsuit, and it was about 14 months after the accident occurred. So that's one issue. The second issue, under the current version of the statute, Zenith wouldn't have been able to make those equitable arguments to the trial court that the settlement was not for the full value of the claim. Under the current version of the statute, unlike the statute that was at issue in Smith, the court is not allowed to take into consideration any equitable considerations that would increase the employer's share of recovery. So
that's not true, ma'am, because you can argue before the court, and it's clearly in the statute. You can argue before the court whether Morgan and Brennan acted in bad faith in order to reduce your recovery. It's there.
That's in the prior version of the statute, Your Honor, but with all due respect, it's not in the current version of the statute. We are not, the court is required to follow
Ma'am, it's an equitable remedy that you're seeking, and the court must do equity because all you have is equitable subrogation. So you can send that up to the second DCA, and if the court refuses to consider those equitable considerations, you'll win. Because it's an equitable remedy that you have. The court must do equity when you're seeking the portion of your lien. So the court can consider the party's conduct when they settled this case.
I think under the plain language of the statute, Your Honor, the legislature does not allow the court to have that authority. It's a mandatory statute. The legislature uses the word shall throughout the statute, and it says that the formula, it's a very specific mathematical formula that doesn't have any equitable considerations mentioned in the new statute. In the old statute, it mentioned equitable distribution. That word is not present anywhere in the current version of the statute. It's a strict mathematical formula under 440.393.
Yeah, but subsection 3A allows the court to consider the employer carrier, the failure of the employee to comply with the duty to cooperate.
In the settlement, Your Honor, that's a different provision.
And this is a settlement. This is a settlement.
That's during the course of the action. And if you look at that, I think it says the employer, not the employee. It's relating to the employer's duty to cooperate with the settlement. There's nothing in there that requires the employee to cooperate.
Yeah, but there's plenty of cases, and I read them yesterday, that you can't settle a lawsuit without satisfying a workers' comp lien. There's case law replete with that. And that's what they did in this particular case. So tell me why, based on these circumstances, that your employee insured fully and completely settled her case and released the defendants that you seek to sue. Tell me why you have a right, other than to seek equitable distribution, you have a right to file a lawsuit against them to recover their lien when they fully have settled with her.
Sure, and I think that this comes back to the plain language of the statute. That's where this case should start and end, is with that plain language. If we look generally at subsection 3, that applies in the first year of an accident. So we move to subsection 4 because Ms. Brennan did not file suit in the first year of the accident. So
it doesn't say that she has to.
Well, let's go to
subsection 1, 2, 3, and 4 all say if she settles before suit.
If we go to subsection 4, Your Honor, it does require suit. Subsection 4A, and this is the subsection that we contend is at issue here. It says if the injured employee fails to bring suit against such third-party tortfeasor within 1 year. It does not say if the injured employee fails to bring suit or settle. And that is how the appellees are asking the court to construe it, which would add that additional work.
I have a question. How could they bring a lawsuit if they've settled the case? Isn't Smith 2, the Supreme Court of Florida case, controlling here? The employer under Smith 2 can't sue if there's been a settlement. Is that true or false?
No, I don't think that is true. I think that brings us back to subsection 3B, which says that if the proceeds need to be distributed, then a suit has to be filed within the first year, because that's subsection.
Not a tort action.
No, an equitable distribution or a Manfredo distribution proceeding needs to be filed within the first year by the employee, not a tort action, no. So the employee did not do that. So that brings us to subsection 4, which very specifically says if the injured employee fails to bring suit. Again, it does not say if the injured employee fails to bring suit or settle. And the court respectfully is not at liberty to add words to that part of the statute that weren't put there by the legislature. I think that would extend the statute beyond its terms, and we all know based upon well-settled law that the court isn't at liberty to be able to do that.
Yeah, but we have to read it in peri materiam. We have to read the whole statute in and of itself, and the statute is replete and repeatedly refers to the employee's ability and right to settle the case. They can settle the case. That's uncontroverted. And what you're saying is subsection 4 changes all of that language and means that she has to file a lawsuit and settle it. And that's the only way to bar your right to an action in the second year.
Yes, Your Honor. I think that's the way we should logically interpret the statute together.
Below your co-counsel admitted to the court when the court asked, if Ms. Brennan would have filed a lawsuit, your action would have been barred.
Yes, and that's absolutely,
so that's where we really are. We're splitting hairs over suit and settle.
Well, I mean, I think to your point of reading the statute as a whole, I think that's the only manner in which it can be read as a whole.
Otherwise, down to 1 minute. I'm sorry I didn't remind you sooner.
Okay, that's fine. But I think that's the only way that the statute can be read as a whole, because again, in the overall picture, subsection 3 relates to those first year lawsuits. Subsection 4 is the second year lawsuit and the rights of the carrier. Because Ms. Brennan did not file a distribution proceeding, not a tort action, but a distribution proceeding.
What subsection requires her to file a distribution?
I believe it's subsection 3B, Your Honor. it says before or after suit is filed. If you settle before or after suit is filed, and the parties disagree on the amount to be distributed, then the circuit court has the authority to determine that distribution.
Well, that doesn't require the employee to file anything. It just says the court shall decide it. That means your client has a right to file something.
But we didn't know about it within the first year.
See, you're saying that since she did not comply, well, it doesn't say she has to file something. So what's your next argument?
Well, I think if we look at it that way, Your Honor, that she doesn't have to file anything, then that gets us back to the point of she's going to be sitting on these settlement funds until gosh knows when, because our client didn't know about it.
I don't want to interrupt you, but you've gone over your 20 minutes in full. If you stop now, I'll give you 2 minutes for rebuttal.
Okay. I do. Thank you. Thank you, Your Honor.
You're welcome. Ms. Lalu, Amin, you have your 20.
Thank you, Your Honor. Good morning, and may it please the court. Sarah
Good morning.
Lalu Amin on behalf of the appellees, Ryan Butt Pierce and Larissa Mueller. This court should affirm because the Florida legislature has spoken, and if there were any doubt, the Florida Supreme Court has spoken too. When a claimant settles a claim with an alleged tortfeasor, in this case pre-suit, within a year of the accident, the claimant's comp carrier has a right to equitable distribution from that settlement, not a right to bring its own suit.
Can I ask you a question? Are you referring to Smith too? The Florida Supreme Court has spoken. Is there another case you're referring to?
Yes, Your Honor, that's the case primarily that I'm referring to here and address the precise question on this interpretation issue. And so, Your Honors, I'll jump right into the statute from there, just to kind of walk through the statute's provisions. So subsections 1 and 2 explain the nature of the rights that are at issue here and clarify, although Zenith seems to be disputing, that the carrier's right is one of subrogation. And they acknowledge that in their initial letters to the carriers here. Getting to subsection 3, this portion of the statute sets forth the procedure that applies within the first year of the injury or until subsection 4A is triggered. Subsection 4A provides the procedure that applies once it's triggered within the second year, and 4B provides the procedure that applies within the third year. And this is sometimes referred to as a first, second, or third year sort of setup, but that oversimplifies it just a bit because the first year provisions continue to apply into the second year unless and until the carrier exercises its quote unquote second year rights. And I bring that up because that was the posture in Smith, actually. So the settlement here happened, or rather comparing to Smith, we're very analogous to Smith here. The settlement there happened in the second year after the accident, but the carrier hadn't noticed or filed anything yet. So the claimant continued to have, and they describe it in that case as concurrent rights with the carrier, and carrier and employer are used synonymously in the statute and in the case law. So like Ms. Brennan did here, the claimant in that case accepted responsibility for indemnification of the comp carrier's claim in that case in Smith. So getting back to subsection 3, it provides that within the first year, the claimant can file suit and the carrier can file a notice in that suit that operates as a lien on recovery, not a separate claim, but a lien on the claimant's recovery.
Miss Amin, I know, Miss Keller, I know I gave you a hard time, but I appreciate your consternation because the plaintiff's firm created this mess. You have to admit, Ms. Amin, that Zenith timely filed a notice of lien, correct?
Timely filed a notice of lien. They provided notice.
They provided notice to all parties in that claim, correct?
Absolutely.
And all parties knew about it.
Yes.
And they settled the case without satisfying the lien, correct?
They settled the case and in that process acknowledged that there was a lien and that Ms. Brennan agreed that she would be responsible for taking care of that.
I guess, but the point is they settled it without notifying Zenith.
That's correct.
So that does create some sort of predicament here. Now, Ms. Keller is saying that entitles them to the right to sue, but what do they do if they're never notified and then they ultimately file suit like they did now? They had to file suit because neither one of these parties notified Zenith at all that the claim was resolved.
And that was the claimant's obligation, and the claimant agreed in the settlement that that was the claimant's obligation. Now, unfortunately, that didn't happen right away. But what is telling here is that those funds were still sitting in trust. And so when Zenith filed its action, the claimant promptly filed that equitable distribution proceeding. And so one thing I'm hearing kind of for the first time today is that there was some requirement within the statute to do that within a certain period of time. Against that, that's an issue that they take up with Ms. Brennan, not with my clients. The statute does not provide a time frame for that. And she did do that. And when she did do that, timing clearly isn't an issue for Zenith because they refused to participate. And they said they moved for a stay in that proceeding and said, no, we aren't bound by this settlement at all. In fact, that settlement is irrelevant. We're entitled to pursue a second double recovery against these tortfeasors. That was Zenith's position.
What about Ms. Keller's argument that Ms. Brennan did not have a right to release the tortfeasors from the obligation to satisfy Zenith's lien?
Your Honor, I go back to the terms of the settlement itself. And as was noted, the settlement provides that she agrees to take care of those liens herself. And so this is a derivative right. And so if she has no claim, they have no claim. And this is a statutory mechanism, and it's all dictated by the terms of this workers' comp statute. The health insurance cases that they rely on, subrogation rights generally, don't apply here because we have a statute and the legislature has spoken. So the fact that there was a settlement, they concede that was her right. They concede that she had full authority to do that. And it is a little bit the tail wagging the dog here because the beef is really with Ms. Brennan. And she's the one who didn't file the equitable distribution proceeding right away. It's very interesting. Their positions are very conflicting here. At one point early on, they argued that if the settlement checks had just been made out to Ms. Brennan and Zenith, that my clients would have had no exposure. But because that wasn't done, now they have unlimited exposure. Because this was done by settlement and not a lawsuit, they have unlimited exposure. And that's just not the law.
Well, let me ask you this. Assuming we allow the Zenith lawsuit to proceed, would the release be a complete defense for your insureds?
Yes, Your Honor, under the terms of the statute, under the terms of the release and under the terms of the statute. And it gets around to the problem of this is not how it's intended to work, because as Your Honor noted, what ends up happening there is then Zenith ends up having a claim against Ms. Brennan herself. And that's not how this is supposed to work. This is supposed to, and the case law addresses this, what's happened over the years with the workers' comp statute. It used to be a statute that was primarily for employers. Over time, a balance has been created, and the claimant has the right. The claimant retains the right to sue. The claimant retains the right to settle. Even in that second year, when the rights are concurrent, the employer can't settle on its own. The claimant's agreement is required in that second year. But in the first year, it's all up to the claimant. And there's no assumption that the claimant's counsel are inept to try to maximize their recovery in that proceeding. And again, the equitable distribution is the remedy there. So if there is some issue, that can all come to light in an equitable distribution proceeding. And I want to address that as well, because there's some kind of misnomer in the argument here that we don't have equitable distribution anymore, because now we have Manfredo. Well, the Manfredo court, the Florida Supreme Court in Manfredo, clarified that the formula it was providing, which is ultimately the one that's enacted into this statute, is the mechanism for equitable distribution. So that's exactly what we have here. And it is a claim in equity. And the court can certainly consider all of those things in determining whether, there's a full recovery and how that all shakes out in terms of the pro rata share. So I wanted to address that point too. And Your Honors, unless there's any further questions from the bench here, I would just conclude with, the legislature has struck this balance. Smith has noted the importance of this balance. Smith answered the very question that's before this court today, and it held very unequivocally. And I'd like to quote, if your honors would indulge me. I can pull it up here. It held very unequivocally that the bituminous and Dickerson cases, which are the cases that Zenith continues to rely on here today, these cases that preceded Smith and that Smith accepted cert to address this conflict. And it expressly held that once the claimant settles within that first year, the carrier's right is to equitable distribution. So we have the Florida legislature and we have the Florida Supreme Court, and we respectfully ask that this court affirm. Thank you, your honors.
All right. 2 minutes left for rebuttal. I'm going to hold you to that.
You're muted, Ms. Keller.
Sorry about that. I just want to come back to the issue of the Zenith being able to bring its second-year lawsuit, even though Ms. Brennan had settled. I think had the tortfeasors, because they knew of Zenith's claim, they should not have been able to rely, and they couldn't have relied on the release and on the settlement that Ms. Brennan executed in their favor. So having knowledge of Zenith's claim, they weren't entitled to rely on that. And because they weren't entitled to rely on that, Zenith should be able to bring the second-year lawsuit. And it's not just ordinary subrogation principles that give us that result. The statute, section 440.39, does nothing to change those ordinary subrogation principles with respect to that particular issue. I also want to address very quickly Smith. This is almost a 50-year-old case now. And again, it interprets a prior version of the statute that the court in Smith went to great lengths to address the equitable nature of the statute and the ability of the carriers to argue those equitable considerations to increase the employer's share of recovery. It's very clear from Smith that that was a critical component of its opinion in interpreting the prior version of the statute. Now that the statute has eliminated those words and the equitable nature of the statute, I don't know that Smith, even if it were based on the same similar facts, which it wasn't, even if it were, I don't think that it should be applicable to this case anymore, because the statute upon which it was interpreting has been significantly changed. The facts in Smith were also quite different. That settlement, it took them 2 years to settle, or they settled in the second year.
I'm going to let you know you've got about 8 seconds to finish that thought, if you can do it.
Sure. Here, it was a very hasty settlement, so the circumstances were entirely different. Your honors, with that, we'd ask that the court reverse the trial court's grant of summary judgment in favor of the appellees and remand. Thank you.
Thank you both. Thank you both. We're going to go to the next case. There might be a little bit of housekeeping due, so while these folks exit, we'll speak to the next set.